Sometimes a meeting that's supposed to end a conflict actually starts a brand new one. That's exactly what we're diving into today. It's the story of a settlement conference where one side walked out thinking, great, it's done, while the other side was thinking, hold on, the real trouble might be just getting started.
It sounds like a riddle, doesn't it? But this question is at the absolute heart of a really complex legal fight. So let's unpack this. How can a single negotiation create two totally different parallel realities?
Okay, so everything revolves around what happened on this date. But here's the catch. The meeting itself is a complete black box. It was held under strict confidentiality, which means we can't know who said what. So to figure out what's going on, we have to start with what came after. We've got to follow the paper trail.
And this timeline is our roadmap. It all starts with that confidential conference, right? Then we see the settlement documents get sent out, which leads to a flat-out refusal to sign. Then what seems like a normal next step happens. A trial date gets set. But it all ends with a final, pretty shocking twist, an application to force the very settlement that was just rejected.
First, let's try to see this from one point of view. If you only looked at the actions of one party, an organization we'll call CLBC, right after that meeting, you'd be absolutely convinced this whole case was wrapped up. Done deal.
So, just as you'd expect, CLBC sends over a package with a settlement release and some other forms. On the surface, this is totally standard procedure. It's just the final paperwork to close the file. It really gives off this vibe of finality, like, okay, we're all done here.
Everything they did, from the documents to the follow-up emails, it all just screams that, in their system, a box has been ticked off. It's marked as settled. The only thing left to do was get a quick signature to make it all official.
But the moment that package landed in the claimant's hands, it was like they were looking at a document from another dimension. The words on the page weren't just a little off. They seemed to describe a future that the claimants were sure they had never, ever agreed to.
And this phrase right here is the core of their entire legal argument. No meeting of the minds. It's a formal way of saying, hey, we were never actually on the same page. A real agreement was never reached because both sides didn't have the same understanding of what they were agreeing to. That metaphorical handshake, it just never happened.
And this is so important. For the claimants, that dotted line wasn't a finish line, it was a starting pistol for a whole new set of problems. Signing that document wasn't just a formality. It meant agreeing to a deal they felt was incomplete and honestly pretty dangerous for them.
So let's get into the nitty-gritty. What exactly was in this document that made the claimants put the pen down and say, there is no way we're signing this?
When they saw a few huge red flags. First, there were no written guarantees on things they considered absolutely essential. Second, some important conditions they thought were part of the deal just weren't in the text. And maybe most critically, signing it would create brand new, vaguely worded obligations that could lock them into future financial and legal risks, all while closing the book on their original claim.
So what you have here is a complete deadlock. You've got CLBC acting like an agreement is already in place, and you've got the claimants saying we literally cannot sign this document. It's one conference, one pile of paperwork, but two totally opposite truths.
Faced with this situation, the claimants made a very clear choice. They decided they'd rather have a transparent court process than a settlement they completely disagreed with. So they formally let the court know, putting it on the record. The document isn't signed because, from our perspective, no agreement was ever reached.
So what's supposed to happen when settlement talks just completely fall apart? Well, the legal system actually has a pretty standard, predictable playbook for this exact scenario.
The claimants filed their refusal and asked for a trial, and the court, just following normal procedure, accepted their filing and put a trial date on the calendar. Now, it's really important to get this straight. This isn't the court picking a side. It's just the system moving on to the next logical step when negotiations fail.
At this point, you'd think the whole game is about to change. The time for quiet, off-the-record chats is over. The path ahead looks pretty clear. An open courtroom with witnesses, public transcripts, the whole shebang.
But just when you think you know where this story is going, it takes a sharp, and I mean sharp, unexpected turn. Instead of getting ready for that trial, CLBC's legal team filed something new. It wasn't about arguing the original case. It was about forcing that rejected settlement right back onto the table.
And this is what they filed, an application to enforce settlement. This one document completely changed the focus of the entire fight. The main issue wasn't the original claim anymore. Now it was a battle over whether an unsigned piece of paper could be legally declared a binding contract.
This application had three big asks. First, it wanted the court to just declare the unsigned text a binding deal. Second, it wanted the court to actually force the claimants to sign it. And, kind of as a backup plan, it suggested holding another conference with the very same judge.
And this move creates a huge fork in the road. On one path, you've got a public trial, where evidence decides who's right. On the other path, you have a motion to force a settlement and skip the trial altogether. The fight was suddenly about the very idea of justice itself.
So that's where we are right now, stuck at this incredible crossroads. A trial date is officially on the books, but at the exact same time, there's this whole other legal battle happening to try and make that trial disappear and instead enforce an agreement that one side is adamant never even existed in the first place.
Which leaves us with this final, really puzzling question. Why would one side work so hard to force an unsigned agreement on someone else? An agreement that the other party sees not as a solution, but as a whole new set of unacceptable risks. We don't have the answer, but the stage is now set for a legal showdown that's about a lot more than just the original dispute.